One of the most common and important questions that we get asked in the context of assessing the enforceability of a non-compete agreement is how long the non-compete agreement is supposed to last. And the reason that this question is critical is actually kind of obvious and logical. During that time period, the employee is supposed to sit on the sidelines and refrain from working or bringing home a paycheck in his chosen field. There's no question that this is a most serious issue. So how have New York's courts handled this question? Unfortunately, insofar as New York is concerned, there really isn't a clear-cut answer which says, under New York law, a non-compete clause will not be enforced if it exceeds X amount of time. Rather, New York's courts have evaluated this issue on a case-by-case basis to see whether the non-compete is reasonable and calculated to protect the former employer's legitimate business interests. Thus, for example, while a 2-year or a 3-year non-compete for some specialists, such as in the medical field, may be upheld, a similar time restriction on a regular salesperson might be invalidated. Consequently, it should come as no surprise that New York's courts have held invalid and unreasonable some non-competes that were as short as 6 months or a year, and in other cases, upheld non-competes that lasted as long as 5 years. Naturally, this is just a very brief overview of a much broader topic. If you have any further questions regarding your non-compete or your non-solicitation agreement, please pick up the phone and give us a call at 516-791-5700 or toll free at 888-497-3410. This is Jonathan Cooper, and thank you for listening.